This is Tom Fox. I'm the Compliance Evangelist, and welcome to episode 303 of the FCPA Compliance Report. Today I have with me Greg Keating. Greg is a partner at 608 Hall & Stewart in Boston. He heads their labor and employment and whistleblower practice. He talks to us today about his whistleblower defense practice. And he also talked to us about a very interesting upcoming conference about whistleblowers entitled Whistleblowers Compliance, put on by the Financial Research Associates. Greg is a co-chair, and he takes us through the agenda of the conference, who some of the conference speakers are, gives us a tease of some of the highlights, and I think you're going to find it very interesting. If you are interested in whistleblowers, whistleblowing, defense side, plaintiff side, corporate side, government side, this will be a conference that you should attend. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance Report. Hello, everyone. This is Tom Fox, and welcome to this episode of the FCPA Compliance Report. We are in for a real treat today because we have someone who I've wanted to have on the podcast for some time, Greg Keating. Greg is a well-known whistleblower lawyer expert, if I've got that right. And could you pronounce the name of your firm, Greg, because I never get it right?
No problem. It's Choate, Hall & Stewart. Great.
So Greg is going to talk to us about a couple of things today. First of all is talk to us about whistleblower practice from the defense side, but also talk to us about an upcoming conference that he is chairing, which I'm very excited about, entitled Whistleblowers Compliance, which will be held on February 27th at the Harmony Club in New York, where he and other whistleblower practitioners and experts are going to convene for a one-day event, which really is going to lead the discussion about whistleblowers. So, Greg, with that, I'd first like to ask, you're the chair of the firm's Labor, Employment, and Benefits and Whistleblower Defense Group. Could you explain what that means?
I'd be glad to. So it really falls into three buckets in terms of what we do, what I do. The first would be compliance related, everything from conducting trainings for organizations to auditing their existing practices, policies in a time where we're seeing a lot of action from the regulators. So really just trying to, one of the favorite parts of my job is actually coming in and trying to help employers to make sure everything is set up correctly to ensure a transparent environment. The second area would be conducting investigations, very high-level investigations, either investigations of alleged widespread retaliation or investigations regarding wrongful conduct which whistleblowers bring to light. And we come in and we try and assess, is there really a problem? And if so, we interface with the appropriate government agencies, whether that be Department of Justice or SEC or Department of Labor or anything in between. So investigations would be number two. And then number three, I do litigate a wide variety of whistleblower retaliation suits that are brought under a growing array of statutes, predominantly Sarbanes-Oxley, Dodd-Frank, the False Claims Act, and a growing raft of state statutes which prohibit against retaliation.
Greg, in 2016, we had the greatest year of FCPA enforcement, but 2016 was also the year that the SEC literally crashed through the $100 million mark in whistleblower awards paid. I believe fiscal year 2015, the last year reported, was the highest amount of overall whistleblower awards. And the trend has continued even this week. I believe there was a $7 million whistleblower award. So the conference is incredibly timely. I was wondering if you could give us some of the highlights from your end.
Absolutely. You're spot on when you identify that the lid has really been blown off of things here in the last year. And the note of the $7 million award given to three people last week. I've been on record for a long time saying that the funnel has been getting more and more full at the SEC. It's taken them time to process and investigate the many, many thousands of complaints that they've gotten. And I have predicted for some time now that you're going to see a steady stream of these whistleblower awards, and they're not going to be insignificant, as we've seen from the roughly $70 million doled out in 2016. The conference is really going to be an extremely exciting event. We have a marquee group of speakers who come from a number of different areas. We have government officials who have agreed to speak from some of the most prominent agencies. We have people from in-house perspective from some very, very prominent multinational organizations who are wrestling with and analyzing how best to respond to this changing climate, who are going to weigh in and give their perspective. We have some of the most prominent members of the defense bar that practice alongside me nationally and internationally in this space. And last but not least, we have a number of extremely high-profile plaintiffs' lawyers who practice either in the Dodd-Frank bounty space or in the plaintiff side retaliation against whistleblower space. So it's going to be a very exciting conference just by virtue of those, the wide spectrum of extremely talented experts that we have assembled, but also the content that we're going to dive into.
So one of the things I was most intrigued with the government participants is this is not limited to the Securities and Exchange Commission. This is not limited to a sort of a review or an expose of whistleblower awards under Dodd-Frank. You've got U.S. Commodity Future Trading Commission representative and a Department of Labor representative. So it's really whistleblowing across the government spectrum, but also that would seem to imply that a whistleblower response from the corporate sector would be required. Is that fair?
Yes, I mean the intent in assembling some of these very fine speakers that are in the in-house perspective, alongside the whistleblower defense lawyers who often represent these companies like myself, we're really going to try and identify some of the issues which corporations across America are grappling with, and provide some unique insight into how best to protect oneself in this rapidly changing climate.
So you're going to lead off the conference as the first speaker, and I wanted to see if I could get maybe a hint or a taste of your presentation. And what are you, I guess, two parts. Number one, what are you seeing companies do to react to the recent spike in whistleblower awards? And if different, what are you advising them to do?
So we're going to start off the conference with sort of a deep dive into the landscape and why things are so critically important and why there is such deep water right now. We're going to canvass the expansion of rights and remedies under new court decisions that have come out and new legislation that continues to evolve, the increasingly aggressive government agency initiatives that have put companies at risk and expanded rights and remedies. And we're going to look at what companies are doing specifically in response to those things. So for just as one concrete example, there's been a real proven attack on corporate agreements and policies which have the purpose or effect of muzzling whistleblowers. There have been in the last year at least approaching half a dozen six-figure civil money penalties imposed at the SEC, and we're going to provide some concrete guidance and advice from the in-house perspective and the defense bar on how to avoid that minefield, and also some concrete advice flowing from some very, very recent Department of Labor recommended best practices around how to have an effective compliance program with a focus on the critical importance in this day and age of training. Tom, you still there?
Yes. Sorry. We have a very high-profile whistleblower case, which is going to trial right now in California, involving the former general counsel of a company called Biorad, who was terminated and alleged he was terminated for bringing forth allegations of bribery and corruption in China. That case has really laid some groundwork around the attorney-client privilege, the role of a general counsel or perhaps even a chief compliance officer and what they may disclose to the regulatory authorities. And it has put a lot of things up in the air that many of us had hoped, at least, with regard to the attorney-client privilege, were settled. Is that one thing that you think will come up at the conference?
There's simply no doubt that one of the many hot topics in this space is the rising tide of in-house counsel and compliance professionals as the whistleblower. And that is a hot topic which will be addressed. Other hot topics that will likely be addressed include, but aren't limited to, whether whistleblowers can take confidential information in direct violation of a confidentiality agreement and nonetheless proceed as a whistleblower. And also whether or not would-be whistleblowers can engage in other opposition which arguably is unreasonable, and whether those whistleblower rights will trump otherwise legitimate company policy. So there's a lot in this space that is really sizzling right now, and the rising tide of in-house counsel being one of them that we intend to address.
I was particularly gratified as a recovering trial lawyer and someone who's moved more into the nuts and bolts drafting and the doing of compliance, that you really have a large chunk of the conference dedicated to that issue. How do you do compliance? And you specifically mentioned training, but there's also a session specifically on drafting and creating effective employment separation agreements, settlement agreements. Obviously, I'm from Houston, so that is very much in the mind of many companies today because of the economic downturn still going on in the energy space. But it's more than just the litigation. It's certainly about the nuts and bolts of how do you craft a policy, how do you train people, and how do you actually do this?
That's absolutely right. And I alluded to the recent wave of SEC-induced enforcement proceedings against companies for overbroad agreements. We're going to take that on. We're also going to take on how to create a integrated complaint procedure so that whistleblower complaints are, in fact, nipped in the bud and processed appropriately. And we're also going to focus on how to conduct an effective investigation, so investigation protocols. All of those topics we intend to address.
Well, Greg, it really sounds like a first-rate conference. You've got regulators, you've got defense bar, you've got corporate in-house, and then you have the plaintiff's bar from whistleblower and retaliation cases. So for any compliance practitioner, for any general counsel, for any lawyer, I think this will be a fabulous conference, and I'm really looking forward to debriefing you afterwards on the outcome. I was wondering, I'm going to, in my show notes, I'm going to list the site to register. We've also got a discount for my podcast listeners. But I was wondering if anyone wanted to contact you directly with any questions, either on your practice or the conference, could they email you? And if so, how would they do that?
Absolutely. Anybody who wants to contact me can do so. My email is G as in Greg Keating, Keating, at Choate, CHOATE.com.
Well, Greg, I really appreciate you taking the time to visit with me, and I'm really looking forward to the conference.
Absolutely. Thanks a lot for the time. Appreciate it.
This is Tom Fox again. If you'd like more information about the conference, you can check it out at the conference website, which is FRALLC.com. That's FRALLC.com. Just go to the Whistleblowers and Compliance event. And listeners to this podcast receive a 15% discount by entering the code CMP, that's all caps, CMP161. This is Tom Fox. I'd like to thank you very much for listening to this episode of the FCPA Compliance Report.